Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for everything you do to support GunGuyTV. I'm super grateful. Great news, great victory. Obviously, it's not a final victory, but I'll take every significant victory we get. Great decision from Judge Carney. And if you're not from California, what it did essentially was take California to task over trying to make almost the entire state a sensitive place where no one can carry. I've got Chuck Michel from the California Rifle and Pistol Association, Michel and Associates, and the Second Amendment Law Center. They're the ones that are fighting the battle for us, and he's going to give us an update on what's going on. So let's go talk to him. Chuck, happy days. Thank you very much for joining me. Great victory yesterday. Obviously, I say that every time, and these are ongoing cases, so it's not over till the fat lady sings, as they say. But great victory so far. Can you describe to us? Okay, first of all, I got to tell you, I read the decision, and I just want to say this. I read the decision, and it read like a children's book. Okay, because this judge is saying, you ask if you could do this? No, you can't do that. You ask if you could do this? No, you can't do that. He went through every one point by point. I went in the other room and I said to my wife, I feel like I'm reading a children's book or something. He's explaining this like you have to explain it to 2-year-olds, that they don't get to throw fits all the time. So it was marvelous. Anyway, what did we get yesterday? What did we win? Where are we?
Okay, so basically this is a challenge to Senate Bill 2. Senate Bill 2 did two things. It created 24 sensitive places where even with a CCW, you weren't allowed to have a gun. And then the second part was, which we haven't challenged yet, was jacking up the qualifications to get a CCW in the first place. But basically, they're making it very hard, trying to make it very hard to get a CCW. Now, we don't have anybody who's been denied yet, so we didn't have standing to challenge those yet, but we will be challenging those. So what we challenged right out of the blocks, and we filed this lawsuit before Newsom even signed the bill. We knew he was going to sign the bill. We were first in court. CRPA filed this challenge because we wanted to get a hearing date before the end of the year. And so we had our hearing yesterday. So the CRPA, joined by Second Amendment Foundation, Gun Owners of California, Gun Owners of America, we've got kind of a good joint venture partnership going on with these guys now, where we're all kind of working together. And we had a hearing yesterday, and the judge did most of the talking to the DOJ, candidly, because we didn't really know what we were trying to figure out. Why that yesterday during the hearing, it became obvious why after the hearing, because 90 minutes after the hearing adjourned, he issued his opinion. So he had obviously.
I've never heard of that. I mean, obviously the opinion was already written.
Yes.
I mean, he didn't write that opinion in 90 minutes.
No, it's a 60-page opinion.
Right.
But he wanted to give the DOJ. He could have held the opinion if he thought the DOJ made a point that he didn't consider. So that's why he asked the DOJ, gave them every opportunity to make their case, but they couldn't. So they didn't change his mind about anything from the oral argument. And then we got the written opinion. And that written opinion is just fantastic. It basically strikes down all the designations of sensitive places. We're still trying to, I still have to digest that opinion because I'm not sure what he did with some parking lots. Anyway, the point is, all the other stuff, all the places that they had condemned, churches, playgrounds, schools, not schools. Schools are still, public schools are still okay. But all the other places, he said, you can't just designate those as sensitive places. These people who have CCWs have qualified for that. They had a background check, and he kept asking the DOJ at the hearing, what evidence do you have of CCW holders committing crime? And the DOJ had nothing, because CCW holders generally don't commit crimes. They're among the lowest in the country for classes of people that get in trouble. And if they do get in trouble, it's typically not because it has nothing to do with their CCW. You know what I mean? So the DOJ just couldn't satisfy the judge. And so the judge issued this great ruling, which strikes down all of these sensitive places. And in the process, and Joel, you said you read it. I mean, it's like poetry. It's like prose. The guy, I mean, see, the argument still is the big issue that's still out there.
I sat here, I was laughing. I loved it. It was a great read. I advise you, if you're watching this, go read the decision. I will put a link in the description. It is a must read. So anyway, go ahead. I'm sorry.
These judges, well, this was Judge Carney. We've had some great opinions from Judge Benitez. There's some judges who get it. They get what the Bruin methodology is. Text and history and tradition. Two steps. The states are working overtime to try and put stuff from step 2 and step 1 and step 1 and step 2. They're trying to obfuscate and confuse. And some judges who are more inclined to be biased in favor of upholding gun control laws, they twist it all around and then they get it wrong. That methodology, whether it's a sensitive places, CCW, semi-auto, magazine capacity, ammunition background check, prohibited persons, it doesn't matter the underlying question. It matters whether the court applies the Bruin methodology correctly, and because if they do, we almost always win. Because the state of California has been passing crap for 2 decades since they took basically control of the Capitol. They've been dancing, on the end of Michael Bloomberg's puppet strings, and or self-promoting themselves like Gavin Newsom does to get his name in the papers and aspire for higher political office. But now all of that is subject to being undone. There will obviously, the government can regulate guns to some extent, but they've never been around about public safety. They've always been about eradicating the gun culture. It is culture side. And anything they can do that they justify in the name of, this is going to make us safer, baloney. But it makes it so hard for gun owners for people to get a gun, own a gun, possess a gun, take it to the range, take it out where they, use it to defend themselves or their family, or for whatever sporting purposes, hunting. They want to make it impossible because they don't want gun owners to be a potent political force. And they don't want, so they can advance their big government nanny state agenda. But so this opinion really kind of took them to task and said, you're full of baloney and none of this stuff survives constitutional muster. So preliminary injunction is enjoined.
So a preliminary injunction, explain that. That doesn't mean the case is over.
No.
That just means that they can't, the law is still in the books or will be on January 1st. They just can't enforce that part of it. Is that how that works?
Correct. When you file a lawsuit, you file a complaint first. That's the charging document that starts it all. And then the state has to respond to that with an answer or some other kind of responsive pleading. But in the meantime, you file the complaint, you can immediately go in for a preliminary injunction. Then as the case progresses, what happens at the end is you get a permanent injunction and judgment if you win. So that's what closes the case, is that final judgment, which can include a permanent injunction. It could include damages. I mean, that's where the relief that you sought in the complaint is either awarded or not in that final judgment. But the preliminary injunction is just that. It's preliminary. Now, you can appeal a preliminary injunction, and that's what the state has already announced it's going to do. But in the meantime, the case in the district court will go on towards potentially a permanent injunction, or to seek some of the other relief for the qualifications that they've jacked up. So now we'll be probably on a 2-track litigation path, where we're in the Ninth Circuit. Well, the state tries to get the preliminary injunction undone, and I'm sure they'll seek a stay too. They always do. And then also back in the district courts, working towards a permanent injunction.
I want to jump in here real quick and let you know that I do not make my living on YouTube. I make a living with my business, Practical Defense Systems. We're a training company. We train security guards in the state of California, and certainly in San Diego, where we're local. A lot of it's online, but in the local area, we also offer the classes that you have to do, where you have to actually show up to class and can't do them online, things like the firearms permit, the baton permit, and all that kind of stuff. And then we also offer concealed carry courses and, all kinds of other things for civilians, NRA courses, CRPA courses, advanced pistol courses, and that kind of stuff. Check us out at pdsclasses.com. What do you think the odds of them getting overcoming the preliminary injunction are in the Ninth? I mean, the Ninth Circuit's not what it used to be.
That's a good question, and that goes back to the methodology. The Ninth Circuit, there's a block of Ninth Circuit judges who hate guns and gun owners and are biased in favor of gun control, and they've twisted the test to try and uphold it. And so I think a lot of these cases are going to get backed up behind the Duncan case, which is in front of an en banc panel right now, again. And this is the second time we've been around this. All these cases got bottlenecked. Remember, if you and I discussed this, all these cases were bottlenecked behind Duncan before Rhodey came down. Then they all got released and sent back down, and then the state started passing all these new laws trying to get around Duncan. It's all subterfuge. I mean, they're just trying to find these creative ways. And by the way, Everytown Law, Bloomberg's group, is spoon-feeding them these ideas, not just in California, but in Illinois, Massachusetts, New Jersey, and Oregon, and other places. So the odds of success in the Ninth Circuit depend on whether or not they get the methodology right in Duncan. And if they get it wrong, it depends on whether or not the Supreme Court sets them straight, accepts it and sets them straight. Now, remember, we also have Rahimi in the Supreme Court right now. That's the prohibited person case, the guy with the domestic violence restraining order. I think the state is going to win that.
That one makes me nervous.
Yeah, well, my prediction is the state's going to win that battle but lose that war, because the court will say on a very narrow ruling, yeah, you can ban this particular guy from having a firearm, but here's the proper methodology, and you're all getting it wrong. Here's the text test. The text of the Second Amendment is covered by the language of the Second Amendment, the right to keep and bear arms, and all kinds of things, all bearable arms, all accessories, magazines, activities, conduct, going to the range, hunting, all that stuff is all covered by the text of the Second Amendment. That was all contemplated as protected activities. And if it's covered by the text, then you move to history and tradition. Is there some historical law that is close enough to this modern day law that indicates that this modern day law is something that the founders would have tolerated back in 1791? And there's not a lot of stuff on that, as Judge Benitez pointed out in the Duncan rule.
They're struggling, it sounds like, these anti-gun folks, to come up with analogous laws because there just aren't very many.
There are laws that disarm dangerous individuals. There are some laws that ban guns in certain places. I mean, there's some laws, but usually what they did was, for CCW, they would have some kind of a surety. Like, you would have to get if you got in trouble to be able to continue to possess your gun and didn't require a permit, you had to get someone to vouch for you. And if you misbehaved again, it would cost you and them money. Now, that's one way to keep people on the straight and narrow, but that was never, it was never an outright prohibition on possessing firearms in 26 different places, different areas, different kinds of places. That was never the way the founders approached it.
SB2, Chuck, has done a whole bunch of stuff. I mean, one is the sensitive place thing. The other is trying to make the permit harder to get. Another part of that is making being an instructor harder to be an instructor. Yep. Right now I had to cancel classes for January because I got to jump through some hoops so that I can start teaching again in February. And for me, that's fine. We just shift our weight and do more security stuff. So I've just added some additional classes for security guards.
Well, you're lucky, because there's a lot of guys who don't have that option.
Right. A lot of guys don't have that option. And the CCW is not our primary business. Training security guards is. So they didn't ding me on my primary business. They dinged me on sort of something we also do. But a lot of guys can't say that. And so there's going to be instructors that are completely out of work or struggling to get this done.
That's not part of SB2. Those are regulations that have not been finalized. The DOJ, remember, when you have a law, you have a statute on the statute books. And then if the state can say, well, look, we're not going to get into the details of what kind of license you have to be an instructor. We're going to leave that to the administrative agency, which is the DOJ. And so then the DOJ has to come up with regulations, which are supposed to clarify and inform the law. So people, if the law is unclear, it's clarified in the regulations. What we've got right now is the DOJ coming out with some regulations about what certifications you have to be an instructor for someone to be trained to get a license, a CCW. And we're fighting that, but those are not final. And it looks like the DOJ may already have backed off because so many sheriffs got involved and said, what the hell are you doing? Because they were going to have people required to get a police officer standard training certificate or all these high hoops that would have knocked out anybody with a CRPA or an NRA instructor certificate, made it impossible for them to train people. And so that's another way, though. See, if you limit the number of instructors, then there won't be that many people who can get a CCW because there's going to be a backlog. And that's part of their game. Yep.
So you say those are not finalized yet. How does that work, and how do we oppose those? I know people
so this
can
is
comment.
part of the Administrative Procedures Act. When they promulgate regulations, they publish them, and then they put out, they offer the public the opportunity to comment on the regs. And we went through this when in 2000, when the semi-auto ban, the Assault Weapon Control Act, was passed, and they had to tell us what a conspicuously protruding pistol grip was. All those features had to be defined. We went through months of back and forth as we made points about how your regs are screwed up, and then they'd fix them, and we'd say that's still screwed up, and they'd fix them. So the regulatory comment period has not even opened yet because the DOJ has not published the real regulations, the actual formal proposed regulations. They sent around a draft, and that's what people are reacting to. And before they even publish them as the final reg that would have a formal comment period where the Office of Administrative Law would oversee this, make sure it's done procedurally correctly, they changed stuff already. So they kind of doing an informal comment period, and the sheriffs and chiefs across the state went nuts when they saw how they were going to limit instructors. But then it will be ultimately a final regulation that has the force of law, just like a statute, under the statute. So that's the process that we're working through.
So I know somebody's going to say, well, why don't you sue about that? But you can't, even if you wanted to sue about it, you can't sue about it until it's final and somebody's injured by it.
It's not the law yet. It's just going through the case is not ripe yet. But we're definitely doing comments. We're submitting comments already.
Kind of like an avocado. Don't try to eat it before it's ripe. You'll break a tooth on the stupid thing. I get it.
I mean, there's ripeness and mootness. It's not ready or it's too late, it's over. So these are wonky little things that lawyers got to deal with all the time. But in the meantime,
at the moment in January for CCW holders in California, because I've heard people say, well, I had somebody comment to me the other day that CRPA only had about a 2% chance of getting this preliminary injunction, and yet I would have said, I'd have bet $1 million you were going to get it, and you got it. So there you go. Now I have people telling me that these regulations are going to get rubber stamped and there's no way to change them. So there's a lot of naysayers and chicken littles out there telling us that the sky is falling.
I mean,
but I don't think it is.
Believe me, I understand it is a rigged game, definitely. Yeah. But that doesn't mean they get away with it always. And it helps when the sheriffs are going to the attorney general and saying, this ain't right, fix it. Because they have, I think, a bit more of a voice sometimes than we do because they don't like us. They want to try and get along with the sheriffs.
And so far, it sounds like the Sheriff's Association and the sheriffs in general have been opposing these regs, so that's a great thing. Where are concealed carry holders as of January 1 right now? I mean, sounds to me like it's pretty much business as usual as far as where they can carry because of this injunction. Is that about where it was?
Yes. Well, I'm sure the state will go try and get a stay, so we'll have to see what happens. But as of now, their permits are good in all the places they've always been good. And so what we really need is people to apply for CCW, especially in LA County. That's where the biggest population base is in the state. Flood them with applications. We're suing them right now to speed up the process. Let's get, I think we have about close to 400,000 CCWs outstanding in California right now. That's not enough. We need, millions.
Okay, so I'm going to ask you that. I'm going to ask you this question. You don't have to answer it because you might be, I don't know, giving your game away. Do we have more lawsuits coming in January? And do you think?
Joel, California and the CRPA, it's Suapalooza, baby.
So many lawsuits, so little time.
Yeah, as long as we have the funding, we will continue to drop the hammer on Gavin Newsom and the guys, because they will continue to come up with little weaselly little ways to try and get around Bruen, and we will continue to drop the Thor's hammer of justice, Second Amendment justice. It's a Second Amendment reckoning, and there's going to be an ongoing fight as they keep trying to weasel out of their obligations under Bruen.
Right. But one step at a time. That's why God gave us 2 feet. Thank you very much for taking these steps. I appreciate you. CRPA and some of these other organizations, Gun Owners of California, and the other ones he mentioned, Gun Owners of America, you mentioned
Second Amendment Foundation.
Second Amendment Foundation. What was the other one?
Gun Owners Foundation.
Gun Owners
and there's
Foundation.
some other groups. This is where I screw up because I can't remember all the littler groups that have joined.
So I'm going to point people to
they're going to take offense.
That's okay, and I don't want to offend any of them. So my point is, when you see the announcements, look at who's supporting this.
And don't forget, in the May case, that's Reno May. Follow him. And the armed scholar.
Who is Reno May?
He's okay, see, you I hate you now. Because this is how deep I am in TikTok and Insta Google Twitter face, the social media universe that I've had to come to terms with.
I'm going to get hate mail now from Reno May.
He's an influencer, and he's a damn
and the
good
Armed
guy.
Scholar. Yes, you should be watching Reno May, and you should be watching the Armed Scholar if you're not doing that. And I know I'm going to get hate mail now, and it's your fault.
Dude, we're too old to try and learn that new trick. Come on.
I don't care. That's fine. Anyway, thank you so very much, Chuck. Have a great week, man. Let me know if something changes, all right? We'll get you back on.
Thanks for getting the word out.
All righty, my pleasure.
Merry Christmas.
Merry Christmas to you, too. Thank you again very much for watching the entire video. I'm super grateful for you, and I'm grateful that you do that. Please do subscribe and share and all that kind of stuff. And if you'd like to support the channel, go over to GunGuyTVcrew.com and do that, or on Locals or on Patreon. Any of those work really well. As soon as I have more news about this stuff, I'll get it out again. And I thank you very much for watching. Have a wonderful week. Have a wonderful Christmas. And wherever you go, whatever you do, stay safe.